From the Library of Congress in Washington, D.C.
I want to just, from the podium, Vicki, thank you so much for rescheduling your entire afternoon to be with us this afternoon. And then just very quickly, for those of you who do not know Vicki Jackson, she is the Carmack Waterhouse Professor of Constitutional Law and Associate Dean of the Transnational Legal Studies Program at Georgetown University. She received her BA and JD from Yale University, and following her legal training, formal legal training, she clerked for a few judges, all of whom you will have heard of, but particularly, of course, she was a clerk for Justice Thurgood Marshall on the Supreme Court. So she's kind of back in her neighborhood a little bit, although she's always around this area. She teaches courses in constitutional law, comparative constitutional law, federal courts, the Supreme Court, and on gender-related subjects. She's very well published. Most of us have read something she's written, if not many things. But I am happy to tell you, Vicki, that our report about Canada's use of foreign law includes a footnote to one of your articles. And that is Stephen Clark, who just kind of said, how could I write this paper without a footnote to Vicki? She's also served in a number of government posts at the Department of Justice and has been a member of the DC Bar Board of Governors and co-chair of a special task force on gender. So without further ado, let me turn the podium over to Vicki Jackson.
Thank you so much. So nice to meet you. Hi, I think I can see you all over this. Thank you, Roberta, very much wrong one, this one, for the opportunity and the invitation to be here, and thank you especially for your flexibility in accommodating my schedule. I was hosting an academic talk by Professor Yuval Shany, who's at Columbia this year, but is the Hirsch Lauterbach Chair at Hebrew University in Public International Law. But I was able to rearrange a little bit to be able to be here to join you. So I'm really very honored to be here. And I want to start off with a thank you to international law librarians who provide completely invaluable help to scholars like me. I have benefited so much over the years from the skill and wisdom of Marilyn Raish, Mabel Shaw, and the other international law librarians at Georgetown, and I can only imagine that all of your faculties feel similarly about your effort. Now, my book, which is called, I brought a copy, Constitutional Engagement in a Transnational Era, the book arose out of my interest in the role of foreign and international law in domestic constitutional interpretation, which is something I began studying in the mid-1990s, well before it became a hotly contested question in the United States. The controversy first arose in '97 in a federalism case called Prince, and then became much more virulent and moved into the halls of Congress in the period 2002 to 2005, largely because of a couple of death penalty cases and the Lawrence and Texas homosexual sodomy statute case. And I then became interested in why the issue was so contentious here and started looking at other countries' uses of international and foreign law in interpreting their own constitutions, out of which emerged this book. The central message of the book is that engagement with transnational sources of law, by which I mean both foreign law and international law, is a helpful and maybe a necessary part of constitutional adjudication in the 21st century. Now, the book has several chapters devoted to analysis of approaches elsewhere, and given the subject matter of your workshop, that's what I'm going to focus on in my remarks. But the book also has chapters tracing the history of the U.S. Supreme Court's reliance on foreign or international law in constitutional adjudication. It has chapters making the normative case for engagement. It has chapter-length studies of federalism and equality law issues in the United States and other countries, Canada and India included, and a final, more speculative chapter about the future relationships of domestic constitutions and transnational sources of law in the 21st century. But my goals in today's talk are limited, as is our time. Primarily, I want to give you a taste from the first 3 chapters of the book about the range of interpretive postures that I have seen constitutional courts around the world take towards the role of the transnational in domestic constitutional interpretation. In the course of doing this, I will say a few words about the debate over foreign and international influence in constitutional law if one broadens the lens from the United States to include other constitutional democracies in the world. And if time permits, secondly, I will try to outline just a few of the normative arguments I have advanced in favor of the Supreme Court's being open to engaging with both foreign and international law, but without committing to what I would call a convergence posture. All right, so I'm going to talk to you now briefly about the 3 large-scale postures I've identified in my book. And these are postures of resistance to the influence of foreign or international law, postures of convergence with transnational legal norms, particularly as represented in international law, and postures of engagement with transnational sources of law, all in the process of constitutional interpretation. So, resistance. In the first chapter of the book, I try and describe this posture in detail. It is manifested in the United States by the position prominently developed by Justice Scalia, and with which I assume everyone in the room is familiar. I tried in the chapter to identify the sources of resistance, and those are many. Among the sources of resistance is a conception of a constitution as a form of particularized self-expression for a particular people. In addition, resistance draws strength from interpretive theories grounded in sort of contractarian forms of originalism. The words have to mean what they meant in 1787 or 1866. What can contemporary foreign or international law tell us about it? And they may also be based on interpretive theories grounded in the idea of reinforcing representative democracy bounded within the territory of a particular national state. So multiple sources feed into it. In some countries in the world, resistance to transnational sources in constitutional interpretation may be a form of resistance to former colonial power or to hegemonic power in the world, including that of the United States. So, for example, Singapore and Malaysia have a doctrine, I love the name, it's called the Four Walls Doctrine. And it arose when lawyers said to them, well, look at these liberal rights-protecting decisions from Western countries. You ought to follow these in interpreting your Constitution. And the court said, we interpret our Constitution within its own 4 walls. So resistance is not limited to conservative justices in the United States. As a jurisprudential matter, as I discuss in the book, resistance may be grounded in quite different approaches, ranging from certain forms of positivism and interpretive strategies associated with that, to much more organic conceptions of law. All right, and I'm happy to elaborate on any of these, I'm just trying to give you an overview. What does the debate look like outside the United States? I'm not sure there's an established constitutional democracy where the debate has been as fierce as it has been here, but that is more a function of the general style of opinion writing in the U.S. Supreme Court in the current era, and of the political mobilization of political parties around issues of constitutional interpretation. Now, the dynamic takes different shape in different courts. In Australia, for example, I don't know if you know, in around 2005 or so, Justices Scalia and Breyer took their debate on this issue on the road. This was the headline in one of the Australian journals that covered it, traveling together to debate the question of whether it's appropriate to use international or foreign law in constitutional interpretation. Now, in Australia, you have a very different debate. Justice Michael Kirby, until recently a member of that court, was very eloquent, but did not persuade his colleagues that the Australian Constitution ought generally to be interpreted in accordance with international law. But he used this approach repeatedly in his judgments. The fact that a justice of the Australian High Court took that position for so many years suggests in and of itself that the contours of the debate are quite different. There is no one in the United States Supreme Court, nor has there been who has made this suggestion about the U.S. Constitution. For a justice in Australia who's more cautious, take Justice McHugh, he says it's perfectly fine to look at foreign law from another jurisdiction, but for Justice McHugh, it would be impermissible to look at international law if it is offered as a rule to be followed. He argued that doing so would undermine the constitutional amendment process in Australia. Quite an interesting position. There are originalists in Australia, but originalism there is called strict legalism, and it's somewhat different from originalism in the U.S. Although both say the words of the Constitution should be understood to mean what they meant when they were adopted, in Australia, strict legalism embraces stare decisis. And as you will know from recent controversies, that has not played so prominent a role in the US. And many Australians are moderate originalists, this is the language used by scholars writing about Australia, who treat the words' meanings as unchanged, but their applications as subject to evolution. So originalists in the United States might reject any sources that don't bear on understandings at the time the Constitution is adopted, but a significant number of the Australian justices, even those who believe in strict legalism, will resort to foreign law in helping to decide open domestic constitutional questions about how the Constitution should be understood to apply. Now, if one moves to Europe, something different and interesting emerges, and I'm now moving into chapter 2 of my book where I discuss the posture of the idea of convergence between and among domestic constitutions and international law. Europe might be thought of as, in some sense, a tremendous incubator of ideas of constitutional convergence. Michael Kirby was a lone voice in Australia, but in Europe, the force of the two different legal regimes interpreted and enforced by two supranational courts, the European Court of Justice and the European Court of Human Rights, create legal pressures towards convergences among the member states. Each of these courts builds a certain amount of its jurisprudence around constitutional traditions common to the member states, which means that there is a doctrinal search for convergences in a way quite different from other parts of the world. And there are many other forces, both legal and sociological, pushing towards convergence. I don't have time to mention all of them, but certainly the European Court of Justice's doctrines of direct effect and supremacy, well established back in the 1960s, strongly push in this direction. Now, interesting to note, these doctrines of the supremacy of European level law in the EU and its direct effect are widely accepted among the member states, except at the constitutional level. Some member states say, yes, our constitution must conform to EU law. Some member states, most notably, I would say led by the German Constitutional Court, have said, no, wait, our constitution is our constitution, and we will evaluate overall compatibility. The possibility, in other words, of resistance, the possibility of resistance is maintained, including in the 2009 Lisbon decision by the German Constitutional Court, which is not in my book. I closed the research in 2008. The court there upheld the Lisbon Treaty, but did so on an account, according to Professor Dan Halberstam, that envisioned the member states and their own constitutional regimes as masters of the treaty. Now, some countries have constitutions that appear themselves in the constitutional texts to mandate certain forms of convergence. In Latin America, there are constitutions which themselves make certain named international human rights instruments of constitutional hierarchy. That's in Argentina, or which, as in Colombia, require that the Constitution's Bill of Rights be interpreted in accord with international human rights instruments. But even, now that's a very strong textual representation of convergence, but even there, the courts have created the possibility for space or distance between the domestic constitution and international law by claiming interpretive power over the meaning of the international instruments insofar as they bear on constitutional interpretation. So, for example, the Colombian Constitutional Court, in its very well-known decision on abortion a few years ago, affirmed that domestic constitutional rights must be interpreted in accord with international human rights treaties to which Colombia is a party, that those international treaties were part of the constitutional bloc, that is the group of sources that legitimately control. But that obligation does not extend to the decisions of the UN Human Rights Committee. Those will be considered, but they're not binding. Who decides what the international instruments mean? The Colombian Constitutional Court. Now, where constitutions mandate convergence, jurisprudential approaches of positivism plainly support considering the foreign and international law. Where constitutions are silent, we've seen jurisprudential arguments from forms of what I would call universalism, or from the idea of an obligation to support the international legal system, or from an idea that transnational law or international law can serve as a check on morally horrific conduct. So once again, multiple kinds of jurisprudential bases for the different arguments in favor of convergence. I want to say a couple of words about doctrines that may be associated with convergence postures. As my very brief tale of the South American provisions is intended to suggest, postures of full convergence are, I think, quite difficult to sustain in the context of interpreting national constitutions. And one sees, even in Europe, which has these supranational courts, the development of doctrines like the margin of appreciation, which is a doctrine that was developed in the European courts basically in order to say, look, we have a uniform standard, but we have to allow some room for the national systems to develop these in their own ways. And in part, I think the reason for that doctrine is that the recognition of the competing pole of the distinctively national traditions. Another doctrine that is associated with the idea of convergence is that of proportionality. Proportionality is regarded in places in the world, I would say in Europe, as almost a universal requirement of public law. And yet, when you look at the proportionality doctrine, which we don't have time for me to take apart for you here, but I'm happy to do in questions if time permits, if you take apart its elements, proportionality could serve as an engine of convergence in result, or it could serve, like the margin of appreciation, as opening up possibilities for quite different kinds of results. Citation or reference to foreign law remains sensitive in many courts. It may be presented to courts in official pleadings put before it by the government, as in France, even if not expressly referred to in the judgments, say, of the Conseil Constitutionnel. Or it may be cited, I'm informed by scholars in Taiwan that the practice there is that the court can cite foreign law in footnotes or in the reasoning section of its opinions, but it's very much frowned on in the holdings. Now, the reasons for the ubiquity of some degree of discomfort about the idea of complete convergence brings me to the description of the third posture, the posture of engagement, and I will try now to combine my description of that posture with some of the normative arguments I mentioned in my introduction. Engagement, a posture of engagement with foreign or international law essentially entails a willingness to consider, but not necessarily to follow, those transnational sources in interpreting a domestic constitution. The South African Constitution provides a nice example. Its language requires its courts to consider international law in interpreting its own Bill of Rights, and it authorizes the courts to consider foreign law in so doing. But note, what this Constitution requires is not to be consistent with. It is rather consideration. Not following, but considering. And in one of its most famous decisions, the Grutbum case, dealing with judicial enforcement of the right to adequate housing, of the right to access to adequate housing, the South African court, while considering international law in detail, and this involved considering the concepts developed in the UN committee that supervises implementation of the ICCSR, the International Covenant on Economic, Social, and Cultural Rights. The parties in that case had argued for the court to adopt the minimum core requirement that had been developed in the UN committee process. The South African court considered it and gave several reasons for why it would be inappropriate to adopt that approach in South Africa, including some minor differences in the wording of the text, some very important differences in the experiences of the court as compared to the committee, and frankly, I think a recognition by the court of the resource limitations implicit in the idea of progressive development of the right. Now, engagement, I have suggested in the book, has both deliberative forms and what I call relational forms. My idea of deliberative engagement proceeds simply from the possibility of better understanding how to interpret one's own constitution by looking at other materials. Totally internal perspective. The idea of relational engagement proceeds from a pre-existing sense of connection to other countries or to the international legal order that relates to one's own constitution. And I'm happy to elaborate these more if you're interested in the question period. But I have one other point I want to make more urgently, and that is that engagement, unlike convergence, engagement postures are not unidirectional. They do not take the position that we should always be moving in this direction. Engagement postures are open to what I would call, under the inspiration of Professor Kim Shepley, aversive uses of foreign or international materials. And let me explain what I mean. So the most important opinion in the Youngstown Steel case, which I'm sure you're all familiar with, is Justice Robert Jackson's concurring opinion. That is the opinion that has gone on in subsequent cases to be most looked to for guidance on the separation of powers issues of what can the executive do without explicit statutory authorization. In Justice Jackson's concurrence, he devoted 2 full pages to analysis of the constitutional approaches to executive power during times of emergencies in 3 other systems: the Weimar Republic of Germany, the Third Republic of France, and Britain's parliamentary democracy in the years leading up to World War II. And the conclusion he drew from this comparison, focusing particularly on Weimar, where the president could declare emergencies, where he said presidents had declared emergencies 250 times in the 13 years of the Weimar Republic until the final emergency, after which we were no longer in a republic. The conclusion he drew was that if a constitution does provide for emergency powers, it should not allow the branch that exercises those powers, that is the executive branch, to be the same branch as the one that determines the occasions for their use. In other words, let it be like Britain, where at least the parliament has to give the prime minister powers, and the parliament sits and can take them away. Now, those 2 pages, until the last couple of years, had been edited out of casebook presentations of Justice Jackson's concurrence for at least 1 generation, maybe longer. So if some of you went to law school when I did in the 1970s and you didn't know he wrote this, that's why. It was not in the casebooks. All right, now as is the case for the other postures, the postures of resistance and convergence, engagement may have a positive foundation in the Constitution's text, as it does in South Africa. Or let me give you another example. Canada is an important constitution in the world in terms of its influence, and particularly the jurisprudence under the limitations or salvage clause found in Section 1 of the Canadian Charter of Rights and Freedoms. Essentially, I'm simplifying and leaving language out, but essentially this says the government cannot take action inconsistent with the rights set forth herein except by a law that can be demonstrably justified in a free and democratic society. That standard, I would suggest, invites the court to make comparisons with the practices of other free and democratic societies, and so the Canadian court has done in its jurisprudence, which is called proportionality analysis, applying Section 1. But engagement approaches may also have resonances with jurisprudences of pragmatism or with an understanding of law as a form of ongoing inquiry a jurisprudential argument advanced by a very distinguished comparativist named Patrick Glenn, who's at McGill. Finally, relational engagement may be based on jurisprudential views connecting local law with transnational law, connecting the local with the global, in which constitutions may serve a kind of mediating role. All right, much more briefly to my second topic, why I have argued for engagement as a posture. You really should read my book if you're interested, but I will try in about 2 minutes to say a little more and then leave time for questions. So first, I reject a posture of general resistance. I do so first because that posture is, in fact, inconsistent with the Supreme Court's own past interpretive practices, which I have spent some years studying. Second, because the law of other constitutional democracies, I think, can provide a useful outside perspective that can help judges gain impartiality and objectivity in interpreting their own law. The threats to democratic self-governance that have concerned some critics, I think, are not threats that arise because our justices consider foreign or international law, just like they might read a scholarly article. Rather, they are threats or concerns or tensions endemic to judicial review in a democracy. There's a tension there, but it's not about foreign or international law. It's about judicial review itself, I think. Now, I also reject the posture of convergence. And here I circle back to the hesitation of some European and South American courts to fully accept convergence with international or supranational law, even when they have texts, binding texts that seem to push in that direction. And that is the role of national constitutions as an expression of national identity, or as a constructor or constitutor of national identity and of a specific national identity. And let me be clear, by national here, I don't mean as in the word nationalities, as in any, I do not mean ethnic or linguistic association. Rather, I mean association as a political community with specific ties that bind people together in that political community as distinct from others. Very briefly, I think that human beings have needs to differentiate themselves in groups from other human beings, and that as human beings we also need to live in territorial space, and for the foreseeable future we'll need to do so. And for those reasons, the need for territorial governments will not disappear, no matter how post-national some phenomena become. The efficacy and legitimacy of territorial government, I think, requires some degree of identification with the government or the law on which it is based. The way I put it in the book is that constitutions, to function well, must be based both on general principles, principles that are viewed as good and thus likely to be widely shared, and on what I call local authorship, or specific practices and agreements of a particular polity. And postures of convergence are inconsistent with the latter idea of local authorship, unless you have a very, very specific form of national embrace of a kind of legal cosmopolitanism. There are many other reasons for engagement that I discuss in the book. I discuss also the relationship among constitutional democracies, their shared interest in helping each other be good constitutional democracies. I also, in terms of reasons for engagement, talk about things like the age of the US Constitution and how much jurisprudence it already has. But in the interest of time for questions, let me stop and invite discussion. Okay. Thank you. You know, I don't know the answer. I'd have to look it up, or I would call Jerry Newman to ask whether the Inter-American Court follows it, because I haven't studied the Inter-American Court very much. Is there an analogy in the U.S.? In a way, you could think of the debate over incorporation of the Bill of Rights going back 30 or 40 or 50 years as being about that question. So one way of thinking about that question was it was clear once the 14th Amendment was enacted that the states were constrained by the idea of due process. So what specifically would due process mean? How much flexibility would the states be allowed in conforming with the new federal constitutional standard of due process of law? You'll all remember that that before the Civil War, the Bill of Rights, including the Due Process Clause of the Fifth Amendment, had been interpreted not to apply to the states, but only to apply to the federal government. So there's a long period of debate, I would say from about the 1890s or so, through the 1960s, and now we have the Heller case in the Supreme Court, dealing with how much specific detail from other parts of the Bill of Rights are incorporated either in the Due Process Clause or in the Privileges and Immunities Clause. Now, I don't think I've searched the U.S. reports for the language margin of appreciation. I don't remember reading it. But a way of conceptualizing the period before incorporation of much of the Bill of Rights might have been one. You could have said that the states in the United States enjoyed a very wide margin of appreciation of how to implement the obligation to provide due process of law. So I'm sorry I don't know the answer in Latin America, but I know who I would ask to find out. I don't want to claim to be an expert in all of European Union law. One of the problems with writing a book like this is that one never feels one has knowledge deep enough, and yet if one is trying to get an overall sense, one skates along on this thin layer. But my understanding is that from the perspective of the European Court of Justice, EU law that the EU is competent to promulgate is supreme over all forms of the domestic law of the member states. However, the member states, as I read what they're doing, do not all agree that it is supreme with respect to their own constitutions. And that is the point of disagreement. Now, I would say on the whole, the decisions I've read or read about attempt to find ways to coordinate. They don't seek out conflict, but the last I looked, which was probably 2 years ago, there was a litigation, there was a question in Poland having to do with the European arrest warrant. And there was a decision of the Polish tribunal that said, this is inconsistent with our Constitution in a couple of ways. And if I'm remembering right, the Constitution was amended to deal with one problem, but not the other. So it looked like, and a couple of commentators, I don't read Polish, so I'm relying on secondary sources, viewed this as a form of incompatibility premised on Polish constitutional requirements. I believe there are some member states that have fully accepted that EU law as a form of binding international law will be supreme at the constitutional level. So there's a diversity of approaches there. And if one takes the position, one of the strongest arguments for convergence that I've read actually is by Yuval Shany. And the argument is that rule of law considerations support convergence so that countries are not subject to inconsistent legal obligations. And certainly, in terms of treaty obligations, all of the, 45 signatories to the European Court of Human Rights and 25 now in the EU, I think that's about right, have undertaken treaty obligations. Now, as you point out, treaty obligations can be satisfied through means other than constitutional interpretation. So there might be a difference between construing your Constitution to mean the same thing as a treaty obligation you have undertaken on the one hand. Second, construing your Constitution not to obstruct compliance with the treaty obligation. Now, we have seen there are some countries, we're sitting in one, where on occasion our Constitution has been construed to obstruct our ability to comply with treaties. That's one way of characterizing the Medellin decision and its relationship to Avena. Not the only one, but it is one way of characterizing that. So when you say what choice do they have, there are choices about whether compliance is done through changing understandings of the domestic constitution to bring it in accord, or through statutory mechanisms, and you might ask what difference it makes. And it may not make a difference in practice, but in most jurisdictions, constitutions are harder to change than statutes. And exiting from treaties, in the EU, it's hard to imagine, although I've seen discussion of it recently. But with respect to human rights regimes, on occasion we have seen countries step out of human rights regimes. This happened in the Caribbean, where some of the countries got caught between a Privy Council interpretation of certain obligations and the inter-American obligations dealing with death penalty and delays. So there may be differences in terms of whether compliance is achieved at the statutory level or at the constitutional level. And I'm afraid I missed much of what I assume was a very interesting comment when you were directing your voice back. I take it you were discussing the Solange cases in the German Constitutional Court. Yes, it was very interesting because the court moved from a posture of saying, we're going to look at each instance that comes up and see if it accords with our fundamental understandings in our Constitution, to then saying, okay, basically, the European level has improved its attention to the kind of fundamental rights we care about, and therefore we're generally going to presume that European law is okay. And that's a very important point, is that these are not entirely separate legal universes. It's a point we might actually generalize, that there are connections between older constitutions in the world and newer constitutions. There are connections between domestic practices and the formation of understandings of customary international law. And so we do live in a very interconnected set of legal orders, however separate doctrinalists might claim them to be. There also, I was thinking as you were talking, I've heard some folks say this, I talk about in my book, that some of the European Court of Justice's more recent decisions, some people claim, are designed to demonstrate to member states, particularly Germany, the adherence of the European Court and the EU to fundamental human rights standards, including the recent Cadi decision, very significant decision by the European Court of Justice, essentially holding invalid under the EU constituting treaty documents European efforts to implement, I think it was UN Security Council 1373 provisions on terrorist financing. And the Cadi Court of the ECJ, which remember starts out as a court about commercial togetherness, finds basically a due process problem in the implementation of this. The problem was that people who had been designated as ineligible for financing or frozen assets because of terrorism connections didn't have a sufficient opportunity to contest the designation, was the gist of what I'm remembering there. Okay.
As a token of our appreciation, we'd like to give you an illustrated guide to the collection We have thoroughly enjoyed your presentation. Thank you for going through at our pace. We really thank you for readjusting your day. It's been fabulous. We had a light lunch so that we wouldn't be sleepy, but I think we could have had a heavy lunch. You would have definitely exhilarated us. Well, thank you so much.
Thank you. Thanks so much for the article.
This has been a presentation of the Library of Congress. Visit us at loc.gov.